Hello, everyone. We're going to start the webinar in about 30 seconds. We see a lot of attendees are logging on. Hello there, and warm welcome to this special webinar that we at Khaitan and Company have put together to talk about the impact of the COVID-19 pandemic on M&A, business and employment in India. My name is Rabindra Jhunjhunwala, and I'm a partner in the Corporate and M&A Practice Group. I will be your moderator today. I will also be speaking on the impact on M&A and business as whole. With me is Anshul Prakash, a partner in the Employment, Labor and Benefits Practice Group.
Hi, everyone.
Situation in relation to COVID-19, we would like to assure you that Khaitan and Company is well prepared to serve its clients and fellow advisors with the same level of quality and efficiency as always. We have already adopted a work from home policy until further notice. In fact, this webinar, we've had to do it remotely as an extra precaution. We've established an internal working group of lawyers to advise clients on COVID-19 issues and also aid the firm in assessing our preparedness and ensuring business continuity. This webinar is our attempt to help you understand the current situation and its repercussions. We will be talking about how the rapid spread of the novel coronavirus across the globe has impacted businesses and what they can do to combat the crisis. The duration of this webinar is about 60 minutes, of which the first 45 will see Anshul and I address the key issues arising out of the extraordinary and unprecedented circumstances that the rapid spread of coronavirus has caused. We will take questions from the audience in the last 15 minutes. If we are unable to answer your questions due to paucity of time, you can be rest assured that we will be in touch over email and get back to you with responses. The slides and a recording of this webinar will also be shared with you after we complete the webinar. Let us now begin with a quick introduction to the topic in question. About 8 weeks ago, coronavirus wasn't a factor impacting the day-to-day decisions. But in a very short period, we have seen it unleash global chaos. Countries as whole have gone into lockdown mode in an attempt to arrest the rapid spread of the disease. Major multinational corporations, entire countries, and recently the whole of Eurozone have adjusted their growth forecasts for the coming year on account of the blow dealt by COVID-19 pandemic. Markets across the globe have witnessed bloodbaths, with the Dow taking historic nosedives and closer home, the Nifty and Sensex following suit. This kind of an impact is unprecedented and lays the ground for a lot of uncertainty about the way forward. It is evident that the impact of this pandemic will be felt for a long time. In such times of crisis, it is important to be cautious and take stock of the situation carefully before moving forward. Let us now talk about some areas of business that are likely to see a significant impact, beginning with M&A. What is the impact on M&A? Global M&A is likely to see a prolonged impact due to this pandemic, and the shockwaves will surely be felt closer home in India too. Several deals at various stages have been impacted by this crisis. With the supply chain being impacted, there will be a cascading effect, which may call for revaluations with respect to various assets that were changing hands or were set to change hands. So, a massive revaluation exercise may need to be undertaken for various deals that are currently underway. This may also call for a more in-depth due diligence exercise from a buyer for the target, especially in terms of any vulnerabilities that may be exposed as a result of this situation. Insurance policies and other compliances must be carefully looked at. Assess any risks of non-compliance, non-disclosures, delinquencies before sealing anything. Now, this may mean extended timelines, but extraordinary times call for extraordinary measures. From the contract perspective, the force majeure clause becomes of paramount importance in such a situation. Force majeure refers to an unforeseen crisis that makes fulfilling a contract impossible. This interpretation of force majeure in the law governing the contract's jurisdiction needs to be carefully examined and understood. Courts may interpret it differently from a case to case, depending on specific circumstances and the severity on the outbreak in the area. Moving on to fundraising, the scale of this crisis has got even the heavyweights of the financial services sectors concerned. For India's financial sector, this is just the latest big blow in a series of setbacks it has been facing in the form of several frauds and scams coming to light, NBFCs struggling to stay afloat, and banks still grappling with the mammoth NPA cleanup task. It is therefore no surprise that lenders have become extra cautious with their lending. Companies, even startups looking to raise funds, may need to review their timelines for fundraising and prepare accordingly to ride out the storm. What does all this do to consumer confidence? Well, it has been massively hit due to the COVID-19 scare. Although panic buying of certain essentials and other fast-moving consumer goods may show a spike in sales, supply chain disruptions and rapidly falling footfalls in retail locations, with several being forced to go into shutdown for social distancing, is a dangerous spot for consumer companies. This is especially tricky for a country like India, whose economy depends heavily on consumption. Once the average Indian starts losing faith in financial instruments, it could very well be back to the days of gold and fixed deposits instead of mutual funds and SIPs. The investor confidence is shaken. FPIs have already started to withdraw large sums from India. As countries start tightening their borders and become more and more closed, foreign investors are likely to get more and more wary of putting their money into emerging economies like India. Businesses and sectors looking to foreign investment for a boost may need to shift to a wait and watch mode for a while. It could be prudent to invest time and effort towards preparing for disputes that may come your way. Any contracts that are in danger of being unfulfilled due to the crisis, updating the overall technology solutions of the company to allow for extended remote working, and recalibrating goals to set realistic growth projections and expansion plans going forward. From a macro perspective, job creation, which has been a sore point for this government and for which several programs have been announced, is bound to be hit. Until the global economy bounces back, investment activity into India may see a slump, which will directly hit job creation. For the government, a serious relook at skilling initiatives and a serious consideration towards universal healthcare and universal basic income may become a necessary soon. We will be delving into details of the employment perspectives shortly. For industry as a whole, this is a wake-up call to ensure that their systems are equipped to allow an increasing number of roles to be performed remotely. This will have a ripple effect with several benefits such as lower office space costs, reduced commute times, lesser pressure on public transportation, which is vital for cities bursting at their seams, and more job opportunities for the specially abled. Those were some of the key takeaways in which M&A and business as a whole have been impacted by the COVID-19 pandemic. Over to Anshul now, who will take the updates from the employment perspective, and he will cover several aspects of what we think are important. So over to my colleague, Anshul.
Thank you, Ramendra. I think in the current backdrop of COVID-19, it is important for all the industry players across sectors to understand what lies ahead and what lies in front of them today in terms of measures which can be taken as employers from a management standpoint vis-a-vis the workforce when it comes to taking the necessary precautions. And a couple of precautionary measures, and I will move in terms of what all actions which can be contemplated by the management in the current scenario. Advisories are sent out, are issued and released by the appropriate governments from time to time on a regular basis. The first and foremost being is to ensure that any trip to the affected or even non-affected areas at this juncture are postponed or cancelled. We are specifically talking about a situation where international travel needs to be completely postponed and put on hold at the moment. Even domestically, when it comes to any business visits or sales related seminars or training programs, at max one can look at usage of technology, but to avoid when we talk about any domestic programs where travel is required to affected areas in this country. The other important aspect is about educating the workforce about basic hygiene. The more important question arises in relation to manufacturing setup, where we have a workforce intensive operation. And from that standpoint, we need to be very clear on what we are telling our employees, whether we talk about the reporting requirements, whether we talk about basic hygiene. In terms of training the employees on a day-to-day basis, apprising them of any fears they may have in relation to personal lockdown in the backdrop of global pandemic. All those aspects are something which the management needs to bear in mind while apprising the employees of the current situation. And of course, goes without saying, self-reporting and self-quarantine measures is one of the most significant aspects when the employees are apprised of the current situation. The other aspect is awareness and training. So we move on from the precautionary measures to the aspect of a direct communication line with the employees. Important aspect would be for all the employers in this country to ensure that they are well accustomed with and well acquainted with the advisories which are issued by the appropriate governments across jurisdictions in this country from time to time. There is a requirement to have the necessary emergency protocols in place, the emergency response teams, and it could be from members from various departments who are responsible to run day-to-day operations. For large and extensive workforce-oriented operations, specifically on the manufacturing side, it is important to ensure that the health and safety officers are well equipped, well trained, and well acquainted with the eventualities which may come in the moment you're looking at a scenario where you are identifying a particular case which might be tested positive. To avoid a situation of panic and to ensure that we have the regular and usual wherewithal, at least to ensure a waiting time is not getting wasted, uh, waiting for the authorities to really come in. Emergency response protocol and containment measures, even on the shop floor, is equally important. Training is equally of significance here when it comes to the workforce, how to spot the symptoms, how to ensure that basic hygiene is not just maintained, but also to ensure that if you face any issues from a health standpoint, you immediately resort to reporting those suspect cases, not just in terms of on the personal front, but also for employees who are looking at a colleague at workplace having those symptoms. Few important measures from workplace standpoint when it comes to managing the staff, the employees across sectors. One is about the anti-discrimination policy. So just because somebody has been diagnosed with or has shown symptoms, due caution has to be exercised to ensure that there is no discrimination which is there on the anvil for that particular employee or member of the workforce, especially from the perspective where the management intends to invoke any clause from the standpoint wherein the issue arises of the employee not being able to render the services for a continued time frame. Now, from that standpoint, it is important for the management to view these perspectives very cautiously. Flexible working environment is need of the hour. Uh, Days are over where you stick to the very basic provisions of your employment policies, where employees are required to report to work. They need to use biometric inputs for placing their attendance at workplace. Uh, Time has come for all the employers to ensure, to the extent possible, that flexibility is exercised to the extent possible. Liberal leave policies are equally important, and I will cover these points in the later slides, where even the government is now emphasizing on the point where, under the applicable law and even from a contractual perspective, employees who are either diagnosed with the symptoms or are showing those symptoms, even asymptomatic employees, are required to be given and accorded necessary time frame to recover. Workplace response standard operating procedures are equally important to be observed, both from the perspective of ensuring that you have the necessary quarantine measures, where you report to the nearest health center or designated facility for any kind of isolation. There ought to be a hotline for the employees, help desk for the employees who are working remotely, and even while working remotely, they are showing symptoms or issuing or having confusion in terms of their health status, because sometimes even from a symptomatic standpoints, it could be a difficult situation for the employee to really guess if at all he is falling within the ambit of somebody who can be tested positive for COVID-19. Moving on from the duties and responsibilities from management perspective, it is also important for the employers to instill confidence in the employees and also impress upon them as to what exactly is their obligation when it comes to cooperating at this hour. Self-monitoring and restraint is the most important aspect which an employee needs to consider at this juncture. Self-monitoring the health, following the basic hygiene, the do's and don'ts, It is all there in the media. There are guidelines from the appropriate governments, but it is equally important for employees to acquaint themselves of what has been conveyed to them on timely basis by the employer as well as the government when it comes to maintaining basic personal hygiene. Of course, avoiding non-essential travel, maintaining social distancing, but to avoid panic is something which needs to be instilled in the workforce and is something which is need of the hour. In case of any travel, and we are talking about non-essential, non-official travels, the employees need to be communicated with the necessary directives in place by the management that they need to report any such planned travel. Of course, it needs to be avoided at this stage under all circumstances, but if at all any travel is unavoidable, whether internationally or domestically, it is important for them to report and intimate the management. Self-isolation and seeking medical help. The superhero syndrome ought to be avoided by the employees. Symptoms, self-quarantine measures for the recommended period, which is currently 14 to 28 days, depending on the nature of how the diagnosis has come through. It is important for the employers to convey that message to the employees in relation to their obligation to report any symptoms and to follow the self-quarantine measures. They need to report and get themselves diagnosed with the nearest identified designated health centers or hospitals. It is equally important for the management to convey the necessary and identified health centers where employees can immediately approach if at all there is an identification on that front. Disclosures is another important aspect, notifying not just the management, the employer, but also the authorities of any symptoms. There are helplines and hotline which can be created by the employers in relation to any health and safety related aspects. If there is any symptom, if there is any confusion, if there is any question pertaining to possible symptoms which one can demonstrate as far as COVID-19 outbreak is concerned, employees can approach and notify the employer. It can be conveyed in a manner that employees are indeed under an obligation from the health and safety policy standpoint to immediately notify the employer, whether they are on their own facing a difficulty on that front or whether there is any colleague on the shop floor. Moving on to the aspects of obligations on the employers and the employees part, a very relevant aspect which has come up in the current backdrop is what many businesses are currently facing is emergency shutdown, and what would be really contemplated in these times in terms of the necessary regulatory requirements. The aspect is about workmen. We are talking about the blue collared employees. We are looking at a scenario where directives have been issued by several governments across the country to shut down operations or to work at a reduced headcount basis. And in those scenarios, unless and until we are looking at a situation wherein the workforce can be allowed or they are capable of working from home, if the operations themselves have to be suspended, we are looking at the possible repercussions from a labor law standpoint. And the employers need to be mindful of the fact that under these situations, they can ask the employees to work from home, and to the extent if they're not able or they're not capable of using the technology, and if the operations are shut down, then the provisions under the Industrial Disputes Act pertaining to layoff on a temporary basis would get triggered. In those circumstances, on a jurisdiction basis, for example, in Maharashtra, it could be exhausting the paid leaves which are currently existing for the employees, and post that for a minimum period of 45 days or depending on the lockdown period, employees, especially the blue collared workforce, will be entitled to at least the 50% of their basic and DNS allowance. So that question is coming up very frequently from players across the sectors as far as the compensation which is payable to blue collar workforce in these circumstances. Another question which comes up is about prolonged closure circumstances beyond the control of the management. If at all any unit has to be shut down, the question is whether steps can be taken to terminate or retrench the blue collared workforce or a part of the workforce. The answer to that would be yes, termination as a measure could be contemplated, but the wait out period is minimum 45 days from the date when you lay off the employees temporarily because of the situation which is beyond the control of the employer. Retrenchment conditions which are contemplated and stipulated under the applicable law ought to be followed in those circumstances. Of course, the notice period, the minimum notice period, the minimum uh, compensation which is payable to the employees in those scenarios ought to be complied with. Notice of closure, notice of retrenchment ought to be sent and issued to the competent authority in the concerned state where the locations, when the location of the operation is. Another question is pertaining to the managerial employees, what ought to be done, what can be done, whether there is any requirement or obligation to continue to pay them minimum compensation, minimum remuneration. The answer would be it is dependent on the internal policies, their individual employment contracts. In terms of termination, there are no statutory conditions which are required to be followed. Uh, it needs to be driven by the contract and the policies. If at all the employer, the management contemplates continuing with the operations for some time, it could be a wait out period for the management employees. Having said that, if at all the management is looking at termination scenario for managerial employees, they need to revoke the necessary provisions in the employment contracts individually. Notice period needs to be complied with under all circumstances. Looking at the government advisories from employment law standpoint, uh, archaic law, which is the Epidemic Diseases Act 1897, has now been invoked, given the extraordinary circumstances where the state governments are now empowered to prevent the outbreak of dangerous epidemic diseases. Now, this regulation has been invoked almost in all the major state jurisdictions in the country, be it Karnataka, be it Maharashtra, Tamil Nadu, Punjab, Gujarat, etc. Uh, there have been instances where very clear directives have been issued by the appropriate governments across these states for temporary closure of public places, malls, theaters, clubs, schools. A very recent directive in a state from a local municipal authority has recently come up in terms of advising and making it mandatory for establishments within the municipal limits to ensure that they operate at a 50% headcount. This is essentially aimed at ensuring and facilitating maximization of social distancing measures. From that perspective, from time to time, even in the last 4 weeks, we have seen software technology park registered units being advised to have their employees work from home. From a full capacity standpoint, laptops, computers, all duty-free equipment can be moved out of bonded premises. Ministry of Health and Family Welfare at the union level as well as at the state level has been issuing guidelines in terms of social distancing measures, advising the employees to work from home to the extent possible. I don't think days are far where you may have mandatory provisions from the appropriate government to ensure that employees are not required to work from their requisite workplaces for a certain period of time. In the IT hub of the country, very recently we have seen a directive where employers have been mandatorily required to accord minimum 28 days leave for infected employees who have been diagnosed with COVID-19 symptoms. there is a requirement, a mandatory requirement for the employers to report the travel history of all their employees for the last 14 days, and it needs to be filed as a report to the health department. There are instances where local units and employers have been called upon by the health authorities, even the IT ministry, to attend meetings, even remotely or through video conferencing, to ensure that and to apprise the government of the measures they have taken so that the reporting requirements are complied with. So that's a couple of points on the employment and labor side and the best practices and necessary measures that are taken by employers across the country as well as the government. I move over to Rabindra.
Well, we are already seeing some questions come in, and we intend to take them all up. That's one reason why we decided to keep some additional time to respond to the questions. Just for everyone's benefit, if you have more questions, please click the raise hand button on your webinar portal and type your questions. We will be picking them up. We already have quite a few questions and we are looking through them. Give us 30 seconds to start answering them. Thank you once again, ladies and gentlemen, and we are formally moving to the Q&A section of this webinar. There are indeed quite a few which have come up. Just one request, if you can be a little more detailed when raising the question and not use acronyms. But Anshul, the first few which I want to club together and ask you, what should an employer do if an employee, other than of course the suspected and infected case, refuses to come to work on the ground of fear of contagion?
So from that perspective, it is important how you are communicating with the concerned employee. One would not advise immediate disciplinary measures in such scenarios because panic is something which can definitely come up, specifically for workforce where they have witnessed a positive case on their premises. The employer needs to apprise the concerned employee of the measures which have been taken for their safety. To the extent required, if it is possible to allow the employee to work from home, that can be done, ensuring and comforting the employee that full pay for the work which they conduct or carry out from home will be assured for them. But an immediate knee-jerk reaction on a disciplinary ground is something which can be avoided at this stage.
And Anshul, are there any separate plans or are there any separate incentives by the government to help smaller companies instead of simply terminating the employees?
So at this stage, government is not really intending to have any kind of specific support system for smaller companies to carry out their operations. Situation is still evolving, and I think the government authorities, especially the Ministry of Labor, will be mindful of the fact that working from home is an advisory situation, but going forward, it may be made mandatory for all the employers across the country. It could be a situation of lockdown. In that scenario, when we talk about closure of operations, there could be guidelines in the near future, but no impetus. There is no kind of a package for smaller companies to face these scenarios, which may result in termination of employees.
A number of attendees have asked about work from home or WFH and questions relating to what is mandatory, what is optional, and especially with respect to IT offices. We have a few others who have asked us for guidelines or any stipulations or anything that we have prepared with respect to work from home. So let's let's ask you, Anshul. Is there anything mandatory which has been put forth by the government? Is it for the entire country, or has it been state specific or city specific? Could you throw some light on that?
Sure. So, from the perspective of Ministry of Health and Family Welfare, at the central level, it has been only an advisory. If you look at the language, it does quote that employers are encouraged. It emphasizes on the fact that you should encourage the employees to work from home to the extent required. Having said that, as of yesterday, there has been a directive from a local municipal authority in Maharashtra, which is the municipal corporation in Mumbai, to really asking the private sector employers as well to work at a 50% headcount, uh, whoever is located within the municipal limits. But for Pune, which could be considered as a principal IT hub, there is no mandatory requirement for employers there to follow that directive. Of course, it has been emphasized upon to ensure that there is lesser amount of interaction and social distancing is maintained at all times to ease the pressure on the public transport at this stage. But there is nothing mandatory as on date when it comes to the Pune jurisdiction. But yes, in Mumbai, which is one of the major financial centers, there has been a directive, at least for the greater Mumbai area, where employees are being required at least on a 50% capacity basis to work from home.
Thank you. And is an employer required to report a positive case of infection occurring at its workplace currently?
So in terms of the guidelines and the regulations which have been issued by various state governments, it does not cast an obligation on the employer to do so, but it is always expected from the employer to be acting more responsibly to ensure that there are necessary measures in place to detect or to at least identify any positive cases. And if at all there is any symptom, immediately report it to the concerned health authority without waiting for the employee to do so. So that is more of a immediate good practice measure which one can observe, but it is not something which is leading to a scenario where if you fail to report, then you can face prosecution. That's not the case at this stage.
And another question maybe related to this is, what if the company doesn't follow the authority's soft advisory? Because you see, some advisories that we've seen are more in the form of an appeal. Can there be potential liability against the company?
At this stage, unless and until there is any specific regulation to that effect, and it makes it mandatory for employers to follow those guidelines in terms of asking the employees to work from home, it is not considered to be a violation of any law. Wherever there are regulations which specify that the employers have to immediately report it, that's something which you need to be cautious of.
Thank you, Anshul. What about employees' obligation? Do they have an obligation to report the occurrence of infection to the employer?
It also depends on the internal health and safety policy, but yes, from an overall standpoint, it could be viewed as a disciplinary issue where, knowing very well that there is a applicable law in this regard and guidelines which are currently existing, not just for somebody as an individual who is employed somewhere, but even as somebody who could be having effect on the larger group or workforce, employer can consider that to be a serious issue, and it could be viewed as a disciplinary point when it comes to taking the necessary measures from a management perspective.
Thank you. We see a lot of questions coming in on the work from home perspective, and leads us to probably get out something more specific to this to all the attendees. And our endeavor would be to put together some FAQs and put together some guidelines on work from home, and send it to all those who have registered and participated in today's webinar. But Anshul, pending any decision from a company, from the company's management on work from home, would an employee be entitled to work from home?
So there is no mandatory entitlement unless the policy would allow the employee. But of course, given the directives from the appropriate governments, one needs to be working on a more positive and flexible basis. If an employee is making claim to work from home and he is very much capable of rendering those services, one may consider allowing the person. Of course, it is not a matter of right. It is something which is an arrangement between the employer and the concerned employee who is making that request.
What about the employer requiring an infected employee to report himself to public health authority?
Yes, absolutely. That is something which can be considered to be a good practice on the part of the employer as a part of the communication, where it is clearly conveyed to the concerned employee and to the entire workforce that if at all there is any symptom, if at all there is any demonstrated symptom of infection from COVID-19 standpoint, the employee is immediately required to report to the nearest identified designated health authority.
And what about company adjusting leaves of a person when the place is shut down? Can salary be paid in full and leaves be adjusted?
So as I mentioned in one of the slides, in majority of the locations, it would depend on the industrial employment standing orders. If you're following the model standing orders, or if you have certified standing orders, leave adjustment is not something which has been provided for under the law. You can continue to pay in case of any temporary lockdown, which is beyond the control of you as an employer. In that case, you can continue to pay 50% of the wages. And it is important for one to consider whether contractually there is any allowed scenario where leave adjustment can be done, because that is a very specific entitlement, and exhaustion of that can be done only in very specific scenarios.
And this is something, the next question, this is something which several people have raised a query about. How does one manage the attendance for employees in case of a WFH scenario?
So there is no specific regulation in terms of how you manage the workforce from a remote location, at least from the perspective of those companies who are technologically more advanced. It can be a measure wherein the login by the concerned employee into his system remotely can be considered as the time when he punches in his attendance. Of course, biometric attendance is something which is completely discouraged at this point, but it could be in the form of a small intimation by the employee that he is now available and he has logged in and he's continued to work the way he would be as if he was in the office premises. So those are the measures which one can take in the form of various formats, even as a policy document or a communication, instead of having any set system which is embedded in the law. Currently, it is not the case.
Any thoughts on who can be considered as a suspect case?
Of course, there are symptoms and issues. Guidelines have been issued by the Ministry of Health and Family Welfare on the symptoms. Common cold, sneezing is not something which can be immediately derived or identified as a symptom. But of course, if at any point in time you see persistent coughing, especially dry cough, and with mild fever or otherwise, it is important for one to immediately consider that could be a suspected case. So one has to be on your guard to ensure that you are identifying those symptoms. Common flu is not something for which you need to be alarmed, but yes, if somebody has persistent cough and it is very much visible that the person is not feeling okay at workplace, it is important for consideration of the fact that he needs to be isolated and the case needs to be reported to the nearest designated health authority.
Great. Just to pause for a moment and let all the attendees know that we are sending regular updates on important developments, including the COVID-19. And if you would like to be added to our distribution list, please do write to us. The email ID is provided in the slide deck. To remind you that we will be circulating the slide deck subsequent to the webinar, and we would be taking a few questions which are very specific offline and send you some responses. Work from home, we will try and put together something for the benefit of all. In fact, the next question which comes up, and this is something which we are considering to have a separate webinar on, we'll keep you informed, is related to data privacy. And what about employer disclosing the identity of an employee who has contracted COVID-19? Is that something which you want to cover now, Anshul? So what happens? Do you disclose that to the rest of the employees? How do you prevent prevent the disease from spreading?
So absolutely, I think from the perspective of sensitive personal data, any health and medical condition or history, it is important for the employer to very clearly assess where they stand when it comes to sharing any data, when it comes to having symptoms of COVID-19. If there's an infected case, the only third party to whom the matter can be reported is the relevant designated health authority. You're not required and you must not be disclosing that aspect to any of the other colleagues or workforce or any other member from the office standpoint, because that is considered to be a sensitive personal data. It should not be sent to any other third party stakeholder, to a contractor, to a vendor or supplier. So that is equally important for everybody to consider. The point when somebody asks that how do you prevent the spread of the disease, the moment there is an identified risk person at the workplace, it is immediately important to have the reporting done, and the reporting has to be only to the designated health authority and to nobody else. The employee needs to move out immediately and be quarantined as per the directives which have been issued by the competent authority.
Well, next one I think I'm going to take up, uh, and I believe I'm being asked to do a bit of crystal ball gazing in terms of what are the predictions for the coming months. Um, I think we may see an overall tone of cautiousness set into the way we do business across sectors and countries. And although some sectors will feel the pinch due to this pandemic, some others will be dealt a much bigger blow than the rest. Case in point is aviation, hotel, leisure, and a few other sectors. Going forward, I do believe that fund managers and investors may look to avoid sectors that require a lot of people movement or require high cost of health and safety compliance. And I believe regulations for these sectors which require more stringent guidelines will come in place once the storm blows over. There are sectors like fintech and healthcare tech which may see more action with demand for such products and services rising. We do believe that there will be a reset and a new normal will emerge. Moving on, again, we do see the interest and we see a lot of questions which are popping up on our screen. Not many of them can be combined. So please bear with us if we are not taking your specific query. We will, as I mentioned earlier, will collate this and send the responses offline. But in case you want any real-time news and updates and you want to be informed about the next webinar and what we are doing, you can also follow us on our LinkedIn and Twitter pages. Going forward, in terms of questions at hand, can a contractor take benefit of layoff if the contractor's client's establishment is shut? Anshul, that is something for you.
Sure. So I think from a contractors and outsourced workforce standpoint, if at all the situation arises where the contracted employees who are deployed at a workplace cannot be really rotated or reassigned to another workplace, contractor can take that plea that there is no operation wherein the concerned outsourced workforce can be redeployed elsewhere. And in that case, the contractor can take the benefit of a layoff situation. Of course, it can be dwelled in deeper, and one can deal with that specific query depending on the facts and circumstances, but that would be the answer at the moment.
And what about organizations that have people who cannot work from home?
So in those circumstances, the first and foremost situation, or I think the advisory would be to ensure that hygiene is something which is followed at all times. Necessary, to the extent possible, we are looking at a situation where you can concentrate on the core work facility instead of looking at the ancillary workforce.
If I may lead you to the next question, which is somewhat related to the one you just answered. How and what is the impact on banks, considering that branches may not be able to shut down and employees will be at risk? Would you recommend anything in particular for such a scenario? And I know
So,
you've covered it in the
sure,
last
absolutely.
answer, but specifically with respect to banks, since one of our attendees have asked that query.
I think first of all, the important aspect when it comes to banking operations is that it would be considered to be an essential service. From that perspective, mostly none of the appropriate government notifications or circulars have advised the banks to shut down or close their operations. But it is important for one to consider, again, I would emphasize on the point about training the employees and having the necessary measures in place to at least ensure that even the third party stakeholders, the customers who are coming onto a particular branch, are also advised to ensure basic personal hygiene the moment they enter the premises, and personal contact ought to be avoided at all times. Touching the notes, currencies, even counters, they have to be sanitized at all times. So those aspects have to be taken into consideration, because this is something which you cannot really forego at this stage.
What about employees raising claims of unfair labor practice if his services have been terminated due to the infection? What are the employee rights?
So very clear assessment would be required in those situations. As I mentioned, probably at the outset, that uh, if the employer is contemplating termination or retrenchment as a measure, or even exit of an employee on medical grounds, you need to very carefully assess the situation, because simply invoking your health and safety policy or individual employment contracts is something which cannot be considered palatable from labor law standpoint. You need to really see if there is a prolonged incapacity to work and render the services which an employee is expected to do. And it needs to be assessed on a case-to-case basis. There is no immediate answer to that question. But given the COVID-19 outbreak, simply saying that medical ground could be a valid ground for termination from services is not something one would advise at this stage.
An interesting one which has come up, and this time it's your turn, Anshul, to do some crystal ball gazing. What do you think the government would do with respect to work from home? Do you see a change in our employment laws in the near future?
I would definitely expect this to be a game-changing scenario. Nobody ever expected this situation to evolve in this fashion, which is going to disrupt the entire industry. Everybody is raising question at present, and the only element which we could see in the past where work from home as a concept was talked about was the Maternity Benefit Act. So from a larger perspective, overall standpoint, it is important that the government would consider those scenarios. I think related to that, another question which has come up is, can maternity benefit be increased basis that the baby has been affected due to COVID infection? I think there is no provision in the Maternity Benefit Act to really talk about a scenario where uh, the infant has been infected and there is a disease due to which you need to increase the maternity leave period. It could be really added to the current leave entitlement of the employee, or any additional leave in that regard would be largely discretionary, because It could be a suspected case where even the mother could get infected. So Maternity Benefit Act does not really talk about or provide for any additional leave provisions unless the mother herself has contracted that disease, and that is more of an individual case, not related to the law at hand.
Very interesting. Thank you. Again, if we move to work from home and its implication on manufacturing facilities where sometimes it may be unviable, any insights we can throw there?
I think need of the hour is to first identify what is your core when it comes to the manufacturing activity, who all can, how you can really thin down the density of your workforce at your factory location or at your manufacturing facility. Please be with an open mind looking at these aspects, because you will be having workforce, you will be having a particular section of headcount who may not be absolutely necessary for those operations. Also, from the perspective where you have a regular employee and an outsourced worker working on the shop floor at the same assembly line, carrying out the same functions, the need of the hour would be to assess whether you can really do without having that additional worker at the assembly line. So I think you need to really structure the workforce in a manner where the headcount is thinned down. You look at having those people not reporting at the work premises, at least as a temporary measure. Otherwise, nobody is really saying that you have everybody working from home, because in a manufacturing setup, that is not a possibility.
Well, we are coming to the end of the session, but let's take a few more questions and stop at the scheduled hour. Ladies and gentlemen, one request, there is a short survey at the end, just 5 questions. We do take our webinars and feedback very seriously. These questions will be visible when the webinar window is closed. Do take a minute and complete that for our benefit, so that the next time round the session is even better. Also, to let you know that we are creating our very own resource center, and we would be providing all our updates on COVID-19 in one place. This will be hosted on our website. Details will be provided, and we would encourage you to continue to check our webpage for the latest information. Anshul, maybe one or two other questions just to finish things. What is the employer's right with respect to collecting and disclosing the personal data which has been collected? And just so that our attendees know, we are going to have a separate webinar where we will deal with data privacy in more detail. But if you can take this, and then perhaps maybe just one more comment before we start wrapping up today.
Sure, absolutely. I think there have been several other questions which I can see on the screen, which are directly related to any right of the organization to seek disclosures in terms of employees who have been tested positive, or if at all employers are looking at as a matter of statutory right to collect that data. The answer would be at an organization level, vis-a-vis the employee in question, when it belongs to the organization as such, you can collect that data. But as I mentioned and responded to earlier, dissemination of that data or transmission of that data to any third party other than the designated health authority is not permissible. One needs to avoid that. Of course, there could be a lot of pandemonium around situations where in a particular commercial complex, an employee may have been tested positive. But in that case, nobody has got the right to seek compulsory disclosure in terms of who was that person who was diagnosed positive from COVID-19 standpoint. So it is all about knowing that there has been a tested case, a positive tested case, but it cannot be the case that you really insist upon disclosure about that person. So that's the sensitive personal data, and any transmission to any person other than the government authority needs to be avoided.
Thank you very much. Ladies and gentlemen, keep in mind we are going to be running another webinar very soon on the impact of COVID-19 on deal making and reviewing contracts. And a few of the questions which have been raised would be directly linked to that webinar. We hope you found this session helpful. We would like to remind you that a recording has been done. We would circulate a link to the webinar. We will circulate the slide deck. Apologies if we haven't been able to get to your question. There have been a tremendous response to the webinar with the number of participants and the questions which have been asked. Feel free to write to us on the email IDs provided on your screen, and we are sure to pick it up and get back to you. With that, we would like to wish you all good health. Thank you very much for joining us today, and stay safe. Thank you, and bye-bye.